Accomplice liability. Accomplice liability can be broken down into a few things. First, the first character to focus on will be the principal. The principal in this case is the actual individual who was present at the crime scene. What it actually means in more detail is that the principal is the person whose acts are the actus reus, the criminal act of the crime itself. For example, murder. The principal is the individual who committed the crime of murder by stabbing the victim. That is the actus reus of the crime of murder. That's the person who committed the act, the principal. The principal must be physically present at the scene of the crime or constructively present at the crime. Physically present. Very straightforward. The defendant committed the murder of the victim by stabbing the victim. He was present at the crime scene. Constructively present. An example of that could be, let's just say that the defendant planted a bomb at a school. He's not actually present at the crime scene because if he was, he would die too, right? Planted the bomb, pressed the button to activate the bomb from afar. That is a situation where the defendant is constructively present instead of being physically present at the crime scene. A second character to keep an eye on is an accomplice. An accomplice is an individual who had the intent for the principal to commit the crime, and the accomplice gave aid to the principal prior to the crime happening. And this happened during the commission of the crime itself, or it can happen prior to the crime. So to break it down a little further is that the accomplice basically is someone who helped out the principal, helped out the defendant commit the crime. An example is that let's say Riley and Israel, they want to rob the bank. Riley is the getaway driver. He drives Israel to the bank, and Israel is the principal. He commits the actual robbery while Riley drove him to the actual bank. That's an example of him being an accomplice because Riley, yes, he had the intent for Israel to commit the crime because, again, they made this agreement to go to the bank and he drove him there. But he gave Israel aid to commit the crime because Israel's the principal in this case because he drove Israel to the bank. That's an example of Riley being an accomplice under this analysis. Furthermore, a little thing to keep in mind is that mere knowledge is not enough. Okay? Just because you know a crime is about to happen, just because you know the principal is going to commit a crime, it doesn't mean that you're going to be an accomplice. So Riley knew that Israel was going to rob Bank of America. Simple knowledge will not constitute him as being an accomplice. If Riley gave any kind of aid or encouragement, assistance to Israel to commit the act of the crime of robbery at Bank of America, then that's enough. However, mere knowledge is not enough. Therefore, if the facts show that the person only had knowledge, that person will not be an accomplice. Lastly, for the character of accomplice in this analysis here is that a principal of the second degree is someone who's also present with the principal at the scene of the crime. Riley would be, technically speaking, a principal in the second degree because, again, he was also at the scene of the crime outside the bank in the car when he first to commit the act of robbery at Bank of America. Then Israel comes out of the bank, they drive away, etc. Because he was physically present, he will be a principal in the second degree. He would only be an accessory before the fact. Before the fact very clearly means that he gave assistance and aid to Israel before Israel committed the robbery. If Riley gave Israel a gun. Hey, Israel, here's my gun. Commit the crime. Come back home. Let's split the money. He gave Israel that aid to the principal, Israel, prior to the crime. Therefore, you could be an accessory before the fact because he gave that aid before Israel committed the robbery by giving him the gun to commit the crime. Lastly, what's very important for accomplice liability is the second half of the whiteboard, which if the principal commits a crime or crimes, plural, other than the crimes that the accomplice assisted on, then the accomplice will be liable for all crimes that are the natural and probable consequences of the act. So basically the foreseeability will be very key for accomplice liability here. Example, let's just pretend that Israel and Riley made the agreement that we talked about. They go to Bank of America, they commit the robbery, Riley's a getaway driver, and Israel happens to kill a teller. Riley didn't want anyone to die, but let's be honest, with a robbery, it is an inherently dangerous felony. Therefore, because it is a natural and probable consequence of a robbery, it was very foreseeable that someone would in fact get killed during the course and scope based on the commission of the crime of robbery, even though Riley did not give aid or had the intent for Israel to commit a murder during the course of the robbery. He will be liable for murder as well as robbery because of the fact that is a natural probable consequence of the act of robbery. However, if the bank, let's say Israel blows up the bank, he brings a bomb in, bank is exploded upon, and the DA is trying to put him down for not only the robbery but also bombing. He will not be held liable for the bombing of the bank because that is not a natural probable consequence of the intended crime of robbery. So again, it must be foreseeable. It must be a natural probable consequence of the crime. If it's not, the defendant will not be held liable. If it is, the defendant will also be held liable for that crime as well, even if the defendant did not intend for that crime to actually happen.